Just 3 days before voting ends, a U.S. District Court judge has ordered the United States Postal Service to speed up the delivery of ballots in Detroit. Michigan and several other states had filed a lawsuit against the Postal Service over a slowdown in operations. The states said the sluggish delivery could harm efforts to properly count mail-in ballots. It's just one of many election lawsuits that have already landed in courts this year. In fact, 2020 is shaping up to be one of the most litigated election years ever. Besides legal fights over mail-in and absentee ballots, both Democrats and Republicans are gearing up for possible lawsuits after the election in hotly contested states. I'm joined now by Richard Briffault. He's a professor of legislation at Columbia Law School. Richard, good to have you with me. So hundreds of lawsuits have already been filed over how and when to count votes and which votes should count. We could see more suits after Tuesday. How unusual is it to see this much litigation ahead of an election?
It's a record amount. I mean, I think there's been more and more election-related litigation in the recent years, really ever since 2000 and the fight in Florida. But I think this is certainly a record. It's been an incredibly unusual year. There's been a lot of fighting and a lot to fight about.
Well, we've seen some seemingly contradictory rulings from the U.S. Supreme Court on mail-in ballots. It is allowing election officials in Pennsylvania and North Carolina to accept ballots in the mail several days after the election, as long as they've been postmarked by the election. But it turned down a similar extension in Wisconsin. First of all, what accounts for the different rulings, and do you think that this is the end of it, or might we see the Supreme Court take this back up?
Sure. The difference is in the cases in which the court sort of clamped down on lower court efforts to allow the arrival of absentee ballots that come in after Election Day, the lower decision came from a lower federal court. And the Supreme Court has a policy of basically barring lower federal courts from changing the election rules in the run-up to an election. In the two cases where the court didn't intervene, the decision came either from a state court or a state court and a state agency working together. And that's actually meant a lot, at least to Chief Justice Roberts, who has been, to some extent, kind of a swing vote in these things. He has voted with the majority that stopped the acceptance of late arriving ballots in Wisconsin, as you noted, but he also was with the other group that would allow them from North Carolina and Pennsylvania. The other half of your question, is this over? Not necessarily. All the ones where the ballots were allowed to come in late in North Carolina and Pennsylvania, that just meant that they weren't going to stop them beforehand. The question may be opened again after Election Day if the party on the losing end wants to challenge the counting of those ballots. And in fact, in Pennsylvania, the Pennsylvania Attorney General and the Chief Elections Officer for the state, they've told the local elections boards to keep those absentee ballots that come in later than usual in a separate pile, in effect, so that in case they're challenged, they can be reviewed separate from all the other absentee ballots, so that that doesn't taint all the absentee ballots that came in on time. So this might not be done.
If it does come back to revisit some of these decisions because one side is unhappy with the election results,
it's going to be a big challenge for the court. Everyone knows who's on the court and how they got there, and everyone knows the significance of all of the many decisions that they're going to have to make in terms of whether this particular if these cases come to them, and I'm not saying they definitely will. The issues this year, if there's post-election litigation, are almost entirely largely going to be about the mailed-in ballots. Did they satisfy all the legal requirements for a mailed-in ballot? And that's we're going to know who's going to benefit from that, or at least we're going to think we know who's going to benefit from that, and we know how the people on the court got there. So I think it's going to be a challenge for them when these cases come up to show that they're being impartial and to show that they are applying the law as they see is driven by the law rather than by other considerations.
Well, important to the institution, obviously. And to follow up on that, you said who's on the court and how they got there. Obviously, there has been a lot of discussion in the public sphere about the latest Supreme Court justice, Justice Amy Coney Barrett, and her position on the Supreme Court. During her confirmation hearing, she was actually asked about whether she would recuse herself from any election cases, given that President Trump himself had said that he wanted to have this justice seated to rule on any election cases that might come up. I'm wondering, from your perspective, do you believe that she will be expected to recuse herself if things come before the Supreme Court in relation to challenges that President Trump is making to this election?
That's a great question. I don't think I have a good answer for you. I mean, traditionally, not just traditionally, each justice decides for him or herself whether to recuse. And typically, the rules on recusal are fairly narrow in terms of when you really mandatory recusal, as if you really are connected to a party in the case. We have not traditionally viewed justices as connected to a party, even if that party is the president and the president is the one who's appointed that justice. This is a very fraught situation, and I think she is going to have to. It's entirely up to her, and she's going to have to balance a lot of considerations in her mind in terms of what the technicals of recusal would require, and what the legitimacy of the court and public opinion might support.
Talk to us a little bit about what a contested election might look like. How are the candidates and their campaigns already preparing for a legal fight after November 3rd?
They are all geared up. They have studied the election in detail, the election laws and all the old election law cases in all of the states, or certainly in any of the states that's considered to be a battleground state. And I think what we're going to see, among many things, is basically challenges to any absentee ballot that came in that wasn't perfectly consistent with the law on the books predating COVID. What's really driving a lot of what's going on this year is the pandemic. The pandemic has led to multiple times as many people using absentee ballots as they did before, and has made it really hard for boards of elections to process all these applications. They're getting 2, 3, 4, 5, 6, 7 times as many applications as before, mailing them out to voters, processing them when they come back. You're getting more voters voting absentee who haven't done it before and who may be making minor mistakes. And so one question is, how closely will the elections officials and the voters be held to complying with every specific of the rules governing absentee ballots? Or is there going to be some leeway? And some of the lower courts have provided for some leeway for voters and for elections officials, also dealing with the delays in the Postal Service for voters and elections officials to accommodate this unprecedented tidal wave of absentee votes. And I think that's what if there is post-election litigation, a lot of it is going to turn on whether or not a particular absentee ballot should or shouldn't be accepted, whether or not it complied with the rules that were in place before Election Day, and whether or not some of those rules were the right rules, or were they rules that were adopted just for this election and were adopted by a local official or a court and not by the state legislature.
Yeah, and both sides in these legal challenges say that they're trying to just ensure a fair election. Right. But many of the lawsuits actually seem aimed at increasing or decreasing vote counts from specific groups. At any point, does a judge look at these cases and just say, this is such a blatant attempt to skew the results in your favor, we're not going to hear that case, or we're not going to entertain it? Or are they obligated, because there is a challenge, to try and see that through?
I think if it's a challenge that comes by somebody with a stake in the election, yeah, that could be a candidate or a political party. They do. And the challenge does have to have some legitimate basis in law. There has to be some argument that the rule change meant to accommodate the surge of voters is unjustified, is unsafe, an argument like that. Whether the judges are willing to kind of pierce the veil and see and acknowledge and take into account that there may be a partisan motive behind it, that this may be designed to drive up the vote in one place or drive down the vote somewhere else, it's hard to say. They're human beings also, but you kind of want to hope that what they are doing is following legal principles, and there are legal principles that support both sides of this, both the kind of being accommodating the emergency. I mean, this really is an emergency. We're in the middle of a national emergency, and it's legitimate to try and revise the rules to accommodate an emergency. And others who are thinking, no, the only people who can make those changes are the state legislatures. And if the state legislature hasn't made the change, nobody else can. And that's really where this divide is popping up over and over again in the litigations in many states.
Richard Briffault, thank you for joining us and helping us to make sense of all of it.
My pleasure. Thank you.